Yes, sir.
ಮೈಸೂರು ತಾಲೂಕು ಕಸ್ಬಾ ಹೋಬಳಿ ಕೆಸರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಎಕರೆ ಜಮೀನನ್ನು ಪ್ರಾಧಿಕಾರವು ಭೂಸ್ವಾಧೀನ ಪಡಿಸಿಕೊಳ್ಳದೆ ಉಪಯೋಗಿಸಿಕೊಂಡಿರುವ ಬಾಬ್ತು ಪ್ರಾಧಿಕಾರದ ನಿರ್ಣಯ ದಿನಾಂಕ 20/11. Oh, I'm sorry, my lord, page 169 at 170.
Yes, yes.
ರಂತೆ ಪ್ರಸ್ತಾವ.
You can read, sir. I'm all ears. Yes.
I know, my lord, your lordships are not only ears, your lordships also have the mind with me.
Of course, yes. That is yes.
That's more important for us, my lord.
Ears with mind on it. Yes. No, I was just searching for something.
No, I'm sorry.
Because,
I'm sorry if I interrupt.
To take it a little further, 14 sale deeds were registered in favor of so and so on 12/1/2022.
Yes.
In terms of that scheme,
Yes.
then immediately it is stopped.
Yes. Yes.
On 14/3/23, saying that no
Yes.
allocation of
Yes,
compensatory
yes,
sites
yes.
henceforth.
Yes. Yes. Answer is yes. Answer to your lordship question is yes.
All right. Yes.
And because on 14/3, my lord, they issued saying stop all further allocation of sites. That is the document.
Was this the last chunk of allocation, not only to the?
I'm unable to answer your question this way or that. I don't know.
All right. Just they will answer, I guess.
I don't know whether after 12/1/2022 and especially after the government order dated 14/3/2023, has there been any further?
I'm not after 14/3 Allah.
After 12/1.
Prior to 14/3/23, whether these 14 sites were allotted to the petitioner's wife alone or to several others, one question. The next is after 14/3/2023, was everything stopped? Those are the two clarifications.
I'm given to understand, my lord, that after 14/3/2023, everything was stopped.
All right. Yes.
Whether anybody else
after 14/3/2023?
No, before.
Before, yes.
That information, my lord, I don't think I'm able to answer your lordship right away because I don't have that information. Now, my lord, your lordship may kindly see, my lord, on 14/3 when the government says stop it, then kindly see, my lord, on seal number 27. The one other aspect, my lord, which may require your lordship's consideration is what is mentioned at seal number 26.
Yes, sir.
Government of Karnataka cancelled the resolution dated 14/9/2020. We are not able to lay our hands on this resolution. So I am afraid, my lord, I am not able to assist your lordships as to what is the cancellation that was done, which is available at page 281.
So what is that resolution 2020? 14/9/2020?
My lord, I'm not able to help your lordships on that, my lord. That's fine.
All right. Yes.
My lord, what that I'm given to understand.
Page 282.
No, that is all right. That, my lord, is, if your lordship will kindly see 27/10, that may show some light on what is this. Give me that. This one, page 281. My lord, kindly see page 200. There is so much of maladministration in Muda that the government, my lord, had appointed a committee and kindly see, my lord, serial number 27.
For what purpose?
To inquire generally into what all is happening in Muda.
That is nothing. There's no bearing on this.
I also see that, my lord, because there is no specific point on which they were asked. But the fact appears to be that
General maladministration.
that is a general. I agree. And then, my lord, there is a show cause notice issued. Now, my lord, seal number 28. A show cause notice issued to the deputy commissioner calling upon Muda to answer the allegations made, which your lordship will find, my lord, at page 292.
All right. Yes.
(292), my lord, there are, again, my lord, if your lordship asks me a question as to whether this has anything specific in relation to the allotment made in favor of the petitioner's wife, the answer to that question is no. There is nothing specific.
So that has nothing to do. Yeah, general maladministration.
General maladministration.
That is in public domain.
Yes, madam.
Yes.
Maladministration is in public domain.
No, true. That's public domain. That maladministration is more in Muda. That's a different thing. Yes.
And then, my lord, your lordship may kindly turn to 29. 9/11/2023, Deputy Commissioner called upon Muda to stop all allotment of sites. And then, my lord, allegation, etc. And then, my lord, 3/7/2024, there was a complaint filed by respondent number 4 before the jurisdictional police, which we brought your lordship's notice, my lord. The magistrate said, how can I proceed afterwards?
No, that's not that.
This is the complaint filed with the police.
Complaint before jurisdictional.
Yes,
police.
correct. Yes, correct.
Then
No,
local.
then, my lord, we have another, that we have, my lord.
First jurisdictional police,
court.
then
And
Lokaयुkta,
then,
then
my lord,
private
seal
company.
number 36.
Yes.
Seal number 36.
That's what Rangnath Reddy told.
Yes, yes.
They've
correct.
complied with all
Yes,
154,
yes,
1,
all
3,
that has been
and
done.
then
All,
200.
all that has been done, my lord, we have set it out. And we also filed a complaint under 200 before the magistrate. Of course, my lord, it was reserved for orders on the question. Special court, I'm sorry, on the question as to whether the governor's sanction was required even to proceed further. It was posted for orders on that question.
It was
When
reserved-
your lordships,
It was reserved for orders. Now it
It
is preserved for orders.
it is preserved for orders.
Because of these.
Yeah, your lordship protection.
Yes.
So, my lord, what was reserved for orders was
It's not
preserved for your lordship protection.
Yes.
That is how it is.
Document for Karipura, page 320. Go to the police station.
Yeah, that's okay. That's okay. Now, my lord, let me go to the order passed by the government at page number 42. Kindly see the order. Now that your lordships have got, these are the factual aspects which I wanted to highlight for your lordships, from which my respectful submission to your lordship is that the connection between the petitioner and the actions which were taken in 2017, which culminated ultimately, my lord, in the execution of the sale deeds in 2022, is quite clear and undisputable. Therefore, my lord, it is not, the question I would pose for myself is whether in 2022 the petitioners had any role. That's not the correct question. It might respect to submission. The correct question will be in 2017. Did the petitioner have a role to play? Undisputedly, yes. And I think, my lord, he was also the district minister. He was also the district in charge.
He was chief minister, sir.
Yes. No, he was deputy chief minister.
Yavaga?
2017.
17.
17
Chief-
years.
17, he was chief minister.
Yes. Where
Yes.
is district in charge?
No, I'm sorry. When? 2004. 2004, he was district in charge. 2017, he was the chief minister. He was chief minister for 5 years, full term.
All right. Yes.
Yes. No, my lord, that's right. Now, my lord, please look at page 42. The petition, my lord, I want to draw your lordship's consideration.
Governor's order.
Governor's order.
Hmm.
Now, my lord, what was told to your lordship was that there is non-application of mind by the government with respect to the question as to whether there is a case for inquiry or not.
That the learned Solicitor General has elaborately.
Yes, I want to point out one thing to your lordships in that. If it has already been pointed out, then, my lord, I apologize for the repetition.
No, I don't
But
know. what-
unless I tell your lordships what I am saying,
know
you
what
can't
you're
say
pointing
everybody. Exactly, my lord. Therefore, that is the reason. I know, my lord, it is a difficult question. Unless I say,
Yes.
you will not be able to say it's already been said. So let me say what I want to say.
So after it is said, I will.
No, of course, your lord. Lord, I recognize, my lord, the court's authority, and the court should stop a counsel if there is repetition. Of course, my lord. Otherwise, this will go. This will be ad nauseum. My lord, kindly now see, my lord, the paragraph number 4 at page 43. It is seen from the decision taken by the Council of Ministers that a committee under the chairmanship of Sri Venkatachalapati IAS was constituted to look into the present matter. However, the government, upon considering the facts of the present matter, as reported in the media newspapers, appointed a high-level single-member inquiry committee under the Commission of Inquiries Act. It appears from the terms of reference of the high-level single-member inquiry committee that there are serious allegations involving illegal allotment of alternative sites, illegal allotment of land, and irregularities in allocation of land. Further, the constituting of a committee under the IAS officer and immediately constituting one more committee under a retired judge of the High Court, and the government's own acceptance that there is a potential big-ticket scam in the allotment of sites by Muda does not inspire much confidence. It is well settled legal principle that persons against whom allegations are made should not be empowered to decide the course of action, even after such grave allegations being involved in the present case. And the fact that the materials prima facie supports the allegation, therefore, decision taken to the council of irrational. That is, my lord.
Now I can say it is already said.
Yes. Now, my lord, please look at paragraph number 6. I have considered the decision of the cabinet dated 1/8/2024. I am going to skip that because it's already been said.
Yes.
Madhya Pradesh, etc., all
Ella,
already been
ella.
said. So I am going to skip that. Now, my lord, please be kind enough to turn to paragraph number 10. That, my lord, is the point that I want to emphasize for your lordship's consideration. Upon perusal of the petition, along with the materials in support of the allegations in the petition, and subsequent reply of Sri Siddaramaiah and the advice of the state cabinet along with the legal opinion, it seems to me that there are two versions in relation to the same set of facts. Therefore, my lord, I pause for a moment here to say the governor, my lord, has said, look, there is one thing that is being said by one set of people. There is another thing that has been said by another. Here is the cabinet which says nothing is wrong. Here is somebody else who says something is wrong. There are two versions. Therefore, I will get it inquired into. And it is very necessary that a neutral, objective and non-partisan investigation should be conducted. I am prima facie satisfied that the allegations and the supporting materials disclose commission of the offence. So therefore, my lord, this much of application of mind in my respectful submission is more than ample. Anything more, there would have been, my lord, an allegation that the
You're
government
reading
has...
the order.
My lord?
You're reading the order.
Yes.
The learned Solicitor General has produced the entire file.
No, my lord. I know, I'm aware of that.
So there is more than what
More
is
than
there.
that. I'm not going into that, my lord. Your lordships are going to look at it. My learned friends are
So
going to...
the submission of not even a semblance traveled to abundance after the original file was placed.
Yeah, absolutely. Absolutely. And I would say, my lord, the original file discloses much more than what the order discloses. Even on the order, it cannot be said that there is non-application of mind. In fact, if anything more had been said in the order, my lord. Now, my lord, lot of material is there available in the file. Whatever is available, my lord, your lordships are
We'll
going to get
consider,
it.
yes.
I'm not going to comment on that. Now, take the order on the face of it.
It does bear application of
It
mind.
does bear application of mind because if anything more had been said in the order, allegation would have been that you have made up your mind on one way or the other.
He is not
No.
authority to make up the file.
Allegation. I'm underlying the word allegation. Is that you would have done it. My lord, you do, you are damned. You don't, you are damned. My lord, this is a very thin line to be drawn. Where is consideration? Where is non-consideration? Now, my lord, this is what I wanted to point out. Now, my lord, what was told to your lordship was, how is it that the petition that has been filed, my lord, we produced for your lordship's consideration the petition that we had filed with the governor of 31/7/2024.
Yes, you told.
I produced-
Memo
Yes, exactly. And I'm sure, my lord, your lordships will look at the records to find out as to whether it is there or not, because insinuations were made.
Which file? Which file it is not there? You've seen. All right.
Sir, is it there or not?
I will also see.
The reference to it, it means the reference to it, we have also not.
We have no, I have had no access, but
Yes. Yes.
anyway, your lordship will look at it, my lord, whether what I say or what
The
he says.
file is given to me.
Your lordship look at it, my lord. Now, my lord, the allegations in the 31/7/2024 communication is identical to the allegation that have been made in the complaint of Mr. T.J. Abraham. Now, my lord, in a situation of this kind, what was told to your lordship was, I was given a copy only of T.J. Abraham's petition. I was never given a copy of the petition filed by respondent number 4, and therefore, the order is vitiated. My lord, and it was made to appear that as if permission is granted to the respondents by this order. Kindly see, my lord, what para 11 says. I think it's a complete misreading of the order of the Honorable Governor by the other side.
Clarified.
My lord, I'll clarify it, my lord.
That is clarified.
I didn't follow.
That is clarified by the Solicitor General.
Very well. If it's been done with it is not a question of anybody being given permission to do anything. It is lifting of a bar. Now, my lord, in this context, if I am right in my submission with respect to paragraph number 11, which has been clarified to your lordships, now, my lord, there's one submission that I want to make. My lord, your lordship may kindly look at one judgment of the Honorable Supreme Court, my lord. There are three distinct concepts. One is a direction, the other is sanction, the third is approval. This is the pyramid. In respect of each of these actions, the standard required is different. Now, my lord, that has been laid down by the Honorable Supreme Court, my lord. In 1952 to SCC 203. 1952, Volume 2, SCC 203. Give it to me. One ನಿಮಿಷ.
SCR.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲ. ಇಲ್ಲಿ kindly turn to page 760.
Now they have done it.
ಮಾಡಿದ್ದಾರೆ ಅದೇ.
ಈಗ ಮಾಡಿದ್ರು.
ಇಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
Right from 50 it is.
ಮಾಡಿದ್ದಾರೆ. ಈಗ ಮಾಡಿದ್ದಾರೆ ಸರ್.
Earlier from 50 to 69 it was SCR. Now it is.
ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ. Kindly turn to page 762. In volume 2. Huh? Well, kindly turn to paragraph number 11 and para 12. Lord, we are not, in the instant, we are not concerned with either direction or sanction. We are only concerned with approval.
Yes.
Well, Lord, kindly see para 11. In both the cases of sanction and direction, an application of mind is necessary. But there is an essential difference that in the one case, there is a legal impediment to the prosecution if there be no sanction. And in the other case, there is a positive order that the prosecution should be launched. For a sanction, all that is necessary for the one to be satisfied about is the existence of a prima facie case. In the case of direction, a further element that the accused deserves to be prosecuted is involved. Therefore, my lord, direction is at a higher pedestal. Then your lordships have sanction, and then your lordships have the concept of approval.
Last 4 lines of that paragraph.
Yes, my lord. Whether sanction should be granted or not may conceivably depend upon consideration extraneous to the merits of the case. But where the prosecution is directed, it means that the authority who gives the direction is satisfied in his own mind that the case must be initiated. Sanction is in the nature of a permission, while a direction is in the nature of a command. So now, my lord, where does this come? This is neither a sanction, neither a direction, it is an approval. Because it is at the bottom of the pyramid. So therefore, if direction requires something more, it requires the highest element of application of mind, and then your lordships have the sanction and then approval. So, my lord, if we look at it that way, then, my lord, the standard required for the purpose of 17A is much less in rigor than for a sanction under 19. Now, my lord, please see para 12. Let us now examine some of the decisions on the subject. For the appellate, on the basis of some of the observations of the Judicial Committee, that a sanction was an important and substantial matter and not a mere formality. The facts in that case were that while there was a sanction of the government for prosecution under the Cotton, Cloth and Yarn Control Order, there was nothing in the sanction itself or in the shape of extraneous evidence to show that sanction was accorded after the relevant facts were placed before the sanctioning authority. To quote the lordship's own words, there is no evidence to report of the sub-inspector, to the district superintendent of police, etc. I'm going to skip that. Prosecution was in a position either to produce or to account for the absence of the report made to the district superintendent of police and the endorsement of the district magistrate referred to in the sanction. It is in this connection that their lordships emphasize that sanction to prosecute is an important step constituting a condition precedent and observe, looked at as a matter of substance, it is plain that the government cannot adequately discharge the obligation of deciding whether to give or withhold a sanction without a knowledge of the facts of the case. Nor, in the lordship's view, is a sanction given without reference to the facts constituting the offence a compliance with the actual terms of clause 23. This, however, is no authority for the position that a sanction stands on the same footing as a direction. Therefore, sanction is different from direction. It is true that the facts should be known to the sanctioning authority, but it is not at all necessary that the authority should embark also on an investigation of the facts, deep or perfunctory, before according sanction. Your Lordship may mark that, my Lord. Even a deep or a perfunctory, he need not do it. The decision lends no support to the view that wherever there is a sanction, the sanctioning authority is disabled under section 556 of the code from trying the case initiated as a result of the sanction. On the other hand, there is plenty of support for the opposite view.
Yes.
Now, my Lord, having shown to your Lordship this, may I now request your Lordship to take my compilation of judgments, my Lord. I'm not going to show to your Lordships, take your Lordship through all this, because in our submission that we have made, we have extracted the relevant paragraphs, my Lord. Though, I must tell your Lordships, my Lord, that it appears, my Lord, that the government in England appointed a commission to go into the merits and demerits of oral arguments in courts and written argument that is prevails, my Lord, in the United States. And the report of the commission was a meaningful shrug of the shoulders of a Queen's Counsel is worth 100 pages of written arguments.
Yes, sir.
But I know, my Lord, but
All right. Yes.
I'll leave it. I have given your Lordships the extracts of the paragraphs, which, my Lord, will not have
We'll harmonize the two.
harmonize the two, and your Lordships may read that, my Lord. But having said that, I want to point out your Lordships one thing. Now, my Lord, kindly look at the scope of 17A, which your Lordships have looked at in several cases. Lord, your Lordships have seen Ashok's case, which is your Lordship's judgment. I'm not going to detain your Lordships on that. But then, my Lord, before the judgment in Ashok came, there was another judgment of your Lordships in Sri Rupa,
Yes.
which, my Lord, your Lordship will find is at page 496, which is in volume 2. Please look at it for a minute. I'm just going to show to your Lordships for a different purpose. I know, my Lord, your Lordships have authored the judgment.
Yes.
Kindly see paragraph number 11. What was it? What was the aspect which prevailed upon this honorable court to hold, my Lord, that the sanction was not, sanction was not enough?
Approval.
No, it just said ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ ಅಷ್ಟೇ.
ಅಷ್ಟಕ್ಕೆ ಅದಕ್ಕೋಸ್ಕರ ಬರೆದಿದ್ದು.
ಅದಕ್ಕೋಸ್ಕರ, exactly. Now, this aspect of the matter, I only wanted to point out, your Lordship, that particular fact which there, your Lordship may kindly see, my Lord, how it has been distinguished. And that is why, my Lord, my respectful submission to your Lordship will be, do not apply the approach that your Lordship adopted in Ashok's case. My Lord, please be kind enough to turn.
Para 29 to 31.
My Lord, please see para 33, my Lord. I want your Lordship to
finding.
33.
But 31 is what is said.
My Lord, what is relevant to not actually is para 39 to 49.
All right.
But please see para 33 for a minute.
Yes, sir.
At page 516. Section 17A of the Act is drafted with the overarching objective of ensuring that unnecessary investigations against public servants are prevented, and the state government is required to take a decision to accord or refuse approval to conduct an investigation within a time frame. This indicates the balance that the law intended to strike in the manner of an investigation being conducted against a public servant. Now, my Lord, please be kind enough to turn to paragraph number 36. I'm going to skip 34 and 35. At this stage, the stark and striking difference.
No, there it was again elaborate. That's why 49, my order is quoted. 50 is said it is mind dismissed.
In fact, your Lordship's order is quoted, and, my Lord, the judge holds because of that ಕೂಲಂಕಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ was the only ground. But then, my Lord, the law is explained further. Now, my Lord, just look at para 40. I'm going to skip a few paragraphs, my Lord, though I thought it's relevant, but summary is there. To summarize, the law has conferred a twofold protection vis-a-vis a public servant for offences under the Act. The first layer of protection is even before an investigation is conducted, where a prior approval is needed under section 17A of the Act. The second layer of protection is after completion of investigation, where sanction to prosecute the public servant is required under section 19. It is clear from the statutory framework the legislature has decided to not only protect public servants from unwanted investigation, but also from a prosecution by making it mandatory for the investigating officer to obtain two different and separate approvals for investigation and for prosecution. It should also not be forgotten that merely because an approval is accorded to conduct an investigation, investigating officer cannot proceed to prosecute the public servant, and he is still required to obtain prior sanction of the government to prosecute the public servant under section 19. Then, my Lord, your Lordship may kindly turn to paragraph number 47.
Caesar's wife
My Lord,
must be above suspicion.
yes. And now, my Lord, no, my Lord, that's after those few lines. The integrity of a public servant is required to be beyond suspicion, as in the proverbial adage, a serious wife must be above suspicion. If there exists even a shadow of doubt on the integrity of the public servant, it will not only harm his system of which he is a part. Thus, in such a situation, if the aspersions cast on the integrity of a public servant and an investigating officer under the Act harbors a view that an investigation is necessary, it would be in the interest of both the government and the public servant that such a nagging suspicion is obliterated. So, my lord, the word emphasizes nagging suspicion. Is it there or not in this case? That's all the inquiry. Some element of discomfort is enough. Unless you're not with that, nothing. I'm so comfortable with what's happened.
Lurking suspicion.
Lurking suspicion is a nagging suspicion.
Nagging.
Anyway, my lord, that's the wording that His Lordship has used. In order to achieve this objective, therefore, the government should be given the greatest degree of latitude to accord. The mere grant of approval to conduct investigation would not lead to an inference that the investigation would necessarily culminate in a prosecution against the public servant. And then, my lord, this earlier Sri Rupa's case, the argument that the materials collected have to be considered meticulously, as indicated by this court in WP number so and so, cannot be accepted for the reason that in the said writ petition, the court was considering an order of approval in that case, where the order of approval merely stated that the government had meticulously considered the matter by use of the term kulankashavagi parishalisaragi. The relevant portion of the order reads as follows, my lord. Then, my lord, para 52. In my view, this indicates that the state has applied its mind to the request made by the investigating officer and has considered the matter rationally before according its approval to investigate the petitioner and another. In the light of the distinguishing feature, the decision relied upon the learned counsel for the petitioner in WP number so and so in support that cannot be of any.
So let governor has applied his mind. in
My
this.
lord?
You want to,
Yes, yes.
you want
this
to
is the-
paraphrase that? Yes.
Yes, my lord. This is-
Governor has applied
Yes,
his mind.
correct. Yeah, absolutely, my lord. That's, and I want to show to your lord, I wanted to show to your lordships, which I believe I have done, to say what was the basis on which your lordship's judgment in that
No,
case
that
was
Sri
made.
Rupa, I'm aware.
That's
yes.
all. That's all. And I wanted to show to your lordship that this is the, and there's another view that has been taken by this honorable court, another coordinate bench. Your lordship may kindly see, my lord, though it arises under 156.3. Please see, my lord, page 522. My lord, kindly turn to paragraph number 48 at 536. But these judgments support the proposition that I am placing for your lordship's consideration, that it should be looked at in a very broad manner, especially having regard to those words relatable to and not commission of or recommendation by. Those words are not there. It is relatable to. In the context of a contractual clause, the Honorable Supreme Court has held, my lord, that these words relating to, in regard to, in relation to, widest amplitude.